is now in session. Be seated.
We'll hear from the appellant.
Hey, please the court. My name is Mark McFall of the Washington County Bar. I represent the appellant, Mary Causby Jackson, in her capacity as administratrix of the estate of her daughter, Samara Elizabeth Jackson. Your Honors, this court observed in Toddy versus Thompson, 121 Southwest 3rd, 676, that few areas of American jurisprudence have been more challenging through the years than the development of the standard of care applicable in medical malpractice cases. And this case is no exception. This case involves the application of what has come to be known the locality rule. The locality rule is stated in Tennessee Code Annotated Section 2926-115 subsection A, and provides that in the healthcare liability action, the plaintiff bears the burden of proving the recognized standard of acceptable professional practice in the profession or specialty that the defendant practices in the community in which the defendant practiced or in a similar community at the time of the alleged injury or wrongful action occurred. Now, before addressing the locality rule, however, I wish to address subsection B of section 2926-115, which states the requirements for a medical expert to be competent to testify. The appellant asserts that there is clearly no genuine question that her medical expert, John F. Steggy, MD, is competent to testify in this action. And I refer the court to Dr. Steggy's curriculum vitae at page 107 of the technical record. Section 2926-115B sets forth the requirements for the medical expert's competency and states that no person in a health care profession shall be competent to testify unless the person was licensed to practice in Tennessee or a contiguous bordering state, a profession or specialty which would make the person's expert testimony relevant to the issues in the case, and that he practiced in his profession or specialty in one of these states, which our medical expert practiced in North Carolina, which is contiguous to Tennessee, during the year preceding the date that the alleged injury or wrongful act occurred. And I believe this case, and Your Honor's resolution of this case, is governed by the Supreme Court case Shipley versus Williams, 350 Southwest 3rd, 527. The Supreme Court stated in that case that in addition to the competency requirements, the admissibility requirements for expert medical testimony come from the Tennessee Rules of Evidence, specifically Rules 702 and 703. Once the minimum requirements of each are met, experience, training, or education bear on the weight of the evidence and not on its admissibility. The Shipley court also stated that in its role as gatekeeper, a trial court is to determine, first, whether the witness meets the competency requirements of section 2926-115B, and second, whether the witness's testimony meets the admissibility requirements of Rules 702 and 703 of the Tennessee Rules of Evidence. The trial court in this gatekeeper role, however, is not to decide how much weight is to be given to the witness's testimony once the minimum requirements are met. Any questions the trial court may have about the extent of the witness's knowledge, skill, experience, training, or education pertain only to the weight of the testimony and not to its admissibility. Dr. Steggy's deposition testimony and his curriculum vitae, I submit, demonstrate that, one, he was licensed to practice medicine in North Carolina which is one of the contiguous states to Tennessee. And 2, he was licensed to practice medicine, and he specifically practiced gynecology, obstetrics, and gynecologic surgery, which makes his testimony particularly relevant to the issues in this case. As the court may have seen in the briefs, this case involved what began as a simple laparoscopic hysterectomy, became an open procedure, and ultimately Samara Elizabeth Jackson developed sepsis, went into critical care, and she was deceased within 4 days, 4 days of being admitted to the hospital. The third thing is that he practiced the profession and specialty in North Carolina. I'm sorry, Your Honor.
Let me go ahead and ask, because time is short. What exactly was the trial court's reason for excluding him?
All right, well, the trial court's reasoning came specifically down to the locality rule.
Yeah.
Just trying to cover all the bases with expert testimony, but yes, time is short. The trial court determined that Dr. Steggy's deposition testimony didn't demonstrate that he had the requisite knowledge of the community in which Dr. Thibault practiced, or a similar community. And we submit that he did demonstrate that. And what the Shipley court, what is instructive about the Shipley opinion is, and I submit one particular word in the Shipley opinion, that the medical expert must demonstrate that he's got a modicum of knowledge of the specific community where the defendant doctor practiced or a similar community. Dr. Steggy did testify, and I know one of the cases talks about some inartfully worded testimony, but he did say he didn't have a whole lot of knowledge about Kingsport, which is where the community where this action originated. But he had checked into the hospital specifically and determined how many beds were in the hospital, what specialties were practiced in the hospital, and so forth. And he had treated patients in the past from the Kingsport area. So we submit that he did demonstrate this modicum of knowledge of either Kingsport, and there was a comparison in the deposition to specifically to Chapel Hill. Dr. Steggy has practiced 30 plus years in Chapel Hill. He's a professor emeritus there at the medical school, and there was some discussion between Dr. Steggy and Andrew Wampler, the appellee's attorney, about the demographics in Kingsport versus the demographics of Chapel Hill. There was some discussion about whether the metro area of Kingsport is comparable, and Dr. Steggy ultimately testified, well, Chapel Hill is about the same population as Kingsport, within about 10,000 people, and it still remains to be a small college town. So he made that comparison. So bottom line, Your Honors, we submit...
When does he have to have this knowledge? Is it at the time the alleged incident occurred, or is it at the time that he testifies?
Well, he did at the time he testified, and there was some discussion in the deposition regarding the whether Dr. Steggy was a proponent of a national standard, and he did discuss the national standard. But ultimately, his opinion, and I think it was his opinion at the time he rendered his opinion when we submitted our designation of our expert, that that what his position was on the standard of care was what a reasonably well-trained gynecologist would do. He took the position that, well, she's a board-certified gynecologist, and a board-certified gynecologist in Kingsport should be held to the same standard as one in Memphis, Knoxville, Nashville, or some smaller town elsewhere.
But that goes to the national standard of care, doesn't it?
Well, he did talk about the national standard, and the Shipley decision does say that's not fatal to his ability to testify.
It's certainly not fatal to it if you say that there is a national standard, but you've got to establish the local standard as well, don't you?
Yes, Your Honor, you do. And I think his testimony was that the local standard.
But my question is, do you have to establish the local standard at the time the alleged medical malpractice occurred, or do you have to establish it at the time you're giving your testimony, or does it make a difference?
I don't think it makes a difference, but I believe you have to establish what the standard of care was at the time the physician gave the care or did the surgery or whatever. Excuse me, Your Honor.
Was that specifically discussed during his deposition?
Yes, I believe that was discussed. Did you form this? Well, I think they talked about the knowledge about the area. Did you form this knowledge or gain this knowledge just before the deposition or when you gave your opinion?
Well, assuming he gained his knowledge at the time he gave his deposition, can that be utilized to show that he had knowledge of the community? Because we don't know that the community, this happened several years before
Yes, Your Honor.
the deposition. So how do we extrapolate that, or can you?
I think it's difficult. I believe what he testified was that his opinion in 2014, when this incident occurred, as to what standard of care of this patient should have been, is the same then as it is now.
I think he was asked that question.
I believe, well, there was a lot of questioning on this locality rule issue, and I think it ultimately came out that that he would have the same standard of care then that he does now.
Okay.
What did he testify to that he knew about Kingsport in 2014?
He testified
when the event occurred.
Well, I think the demographic information he got was as of the date of his deposition.
Which was sometime, that's we don't need the exact date, but it was sometime after the actual.
Yes. This case has been going on for some time.
Yeah. So, I mean, is that a problem for you? I mean, do you have to, that the claimed negligence happened in 2014, but he says he gained his knowledge about Kingsport to satisfy the locality rule several years later. How do we know that the standard of care was the same in 2014 as it was at the time that he gained his knowledge about it?
With all honesty, we'd have to go back at the census data and see what it was then and what it is now. I don't know that it's changed a whole lot. But we're also relying on the similar community issue in that he practices in Chapel Hill, and that Chapel Hill is, although University of North Carolina, Chapel Hill has a much bigger and more capable hospital than I think Holston Valley Medical Center. So it's a little of both. He had a modicum at least of knowledge about Kingsport, and he testified that it was the same standard he would exercise in.
Actually, I want to ask your opponent, because the question I've always kind of wondered, are we talking about the knowledge of the community or knowledge of the medical community?
I think the lines are blurred. I think it's knowledge of the community and the standard of care in that community is really the issue, or in a similar community, which is, your honors know, it's not defined in the statute, and there's been some multiple appeals involving that issue, as well as the knowledge of the community.
I mean, there are certainly towns in Tennessee that I could tell you a great deal about the community, but I couldn't tell you anything about the medical community.
Right,
So
right. Well, part of his testimony was that he treated patients that had come from Kingsport, so he gained some knowledge through that,
All right.
I would assume.
You have your time for rebuttal.
Thank you, Your Honor.
Thank you. We're here from the appellee.
May it please the court, I'm Russell Adkins of the Sullivan County and Kingsport Bar. I'm here on behalf of the defendant, Dr. Lenita Thibault, and her employer, Wellmont Medical Associates. I want to begin by just again stating that appellate courts may not overturn a trial court's ruling admitting or excluding expert testimony unless the trial court abused its discretion. So the question that this court is to decide is whether the trial court abused its discretion in disallowing the testimony of Dr. Steggy. And as Mr. McFall stated correctly, the trial court disallowed Dr. Steggy's testimony in this case because the court found that the testimony did not comply with the locality rule of Tennessee Code Annotated Section 2926115A, which requires in part that the plaintiff establish the recognized standard of acceptable professional practice in the profession and the specialty thereof, if any, that the defendant practices in the community in which the defendant practices or in a similar community at the time the alleged injury or wrongful act occurred. So whether it was proper to disallow that testimony will be really evaluated according to what Dr. Steggy said. So I want to spend just a few minutes talking about what Dr. Steggy said. He admitted in his deposition that he knows virtually nothing about Kingsport. He said, I don't know a lot about it other than it's sort of a medium-sized city. What he knew was about Kingsport and its medical community was limited to what he learned from a web search the night before his deposition. He said he did not look up the population of Kingsport. He guessed the population to be 250,000 to 500,000. I think the court could take judicial notice that Kingsport is a community of 50,000 and has been for some time. When he looked up the website of Holston Valley Medical Center, where Dr. Thibault practices, he did not see OBGYN listed as a specialty. He said, so I'm not sure what that means. He does not personally know any physicians in Kingsport who practice in Kingsport, and he has not talked with anyone who does. He said he knows nothing about the patient population in Northeast Tennessee. So then we get to the comparison of similar communities. He was asked about how Holston Valley Medical Center, where Dr. Thibault practices, compares with the University of North Carolina Medical Center in Chapel Hill, where he practices. He said it is in a totally different league. He said it is different in a lot of ways. He said it's a totally different world. He said he would hope that at UNC they would not act like every small town hospital, and they're not supposed to. He said that the locality standard is an old-fashioned definition. In his view, the focus should be on a national standard of care and is on a national standard of care rather than a local standard of care. So under the Shipley case, which Mr. McFall has discussed, Dr. Steggy cannot offer that testimony unless he first establishes familiarity with the local standard of care. And I would argue that he nailed the door shut with this one answer that I'm about to read to you. He was asked about whether the local standard of care is the same as whether the national standard of care is the same as the local standard of care. He said, you know, ideally they should both be the same. I don't know specifically if there's a separate definition of local standard of care in Kingsport. You know, that's not in a book anywhere. So he has admitted in that one response what was already suggested by the rest of his testimony, which is that he does not know whether Kingsport even has a local standard of care or what that standard of care is, and he would not know where to look to find it. So he just wants to impose a national standard of care, and it would be up to the General Assembly to change that. In her brief, the plaintiff recites two cases, Griffith versus Gorel, which is a Western Section Court of Appeals opinion, and Evans versus Williams, which is an unpublished opinion of the Middle Section Court of Appeals. And it is true that the courts in both of those cases found the expert witnesses to be qualified. But those cases were different because in both of those cases, the witnesses were familiar with the communities where the treatment took place, and both testified very clearly that they were familiar with the local standard of care in those communities. Dr. Steggy did not. He simply disqualified himself by admitting that he's not familiar with Kingsport or the local standard of care in Kingsport.
Opposing counsel says, if I understood correctly, that the doctor had treated a patient from Kingsport. Perhaps it was just one patient. What does that do to your analysis?
It does not change my analysis, Your Honor, because he's testified that he's not familiar with the local standard of care. I don't think that that's enough to establish that he is familiar with the standard of care or with the local community. I mean, I think it would be a totality of all of his testimony. That might be one small nugget. If there were a number of nuggets, it might be enough to add up, but that's the only nugget he has. And he has, as I said, he's already disqualified himself by saying he's not familiar with the standard of care. What
about the discrepancy in the dates? The incident took place years earlier than the deposition. During the deposition, the doctor seems to say that he gleaned his information from some internet search the night before or sometime shortly before, and we've got a discrepancy in the years. What does that do?
Your Honor, it's my position that he would be required to establish his familiarity with the facts and the standards that were in place at the time of the treatment, which he has not done in this case. A web search done the night before his deposition would establish information about basically a new hospital system in Kingsport. I don't recall exactly when his deposition was taken, but there's a lot of changes that have happened very rapidly in healthcare over the last 5 or 6 years.
Do you have any authority that you rely upon to make that statement?
That would be based upon the statute itself, TCA 29-26-115A, which says the recognized standard of acceptable professional practice, and then skipping to the end of the sentence, at the time the alleged injury or wrongful action occurred. So it would be my position that in order to qualify under this statute, you have to establish what the standard was then, at that time, at the time of the treatment.
You haven't seen any cases that have interpreted that?
I've not.
Okay. Thank you.
So it's our position that the testimony was properly excluded, just as the experts were excluded on similar grounds in cases that were cited in our brief, the McDaniel versus UT Medical Center case, the Roberts versus Bicknell case, the Kenyon versus Haldol case. The Healthcare Liability Act was designed to disallow just this type of testimony. Testimony from an out-of-state physician who does not know the local standard of care, but he tries to persuade a local jury to impose another community standards on a local physician. So it's our position that this is precisely the type of testimony that the statute was intended to disallow. If it were allowed at trial, his testimony would be misleading and it would be prejudicial, and the trial court acted within its discretion in disallowing it.
Counsel, let me ask you a question I promised I'd ask you. Are we talking about knowledge of the community, Kingsport, or are we talking about the knowledge of the medical community in Kingsport?
Your Honor, my answer would be, I think the medical community would certainly be more important, but I think that the physician needs to have some familiarity with both in order to be able to be familiar with the medical community. So my answer is both, but more particularly the medical community. The statute doesn't really answer that question, but that would be my argument.
I understand.
The defendant introduced the deposition of a Dr. Stovall as our expert witness, and he negated an essential element of a plaintiff's case. He stated in his deposition that he is familiar with the local standard of care that was applicable at that time in Kingsport. He opines that Dr. Thibault acted within that standard of care preoperatively, operatively, and postoperatively. The plaintiff had ample time to dispute those opinions. The court granted multiple extensions of time to locate another witness after after disallowing the testimony of Dr. Stovall, but another expert was not identified, and the court acted properly in dismissing the case. So we respectfully ask this court to affirm the trial court's ruling and the trial court's order dismissing this case. I'm happy to answer any more questions. I always hate to leave time on the table, but I believe I've stated all that I have to state today.
I hear none, thank you. We'll hear from the appellant rebuttal.
Well, Your Honors, I would respectfully submit that the Healthcare Liability Act was created to favor physicians. Dr. Steggy's testimony says that we're looking at a board-certified gynecologist. He's a board-certified gynecologist. Although we don't have a national standard, a board-certified gynecologist in Chapel Hill or Bluff City, Tennessee, or Johnson City would be held to the same standard. He also testified that when the issue here was the deceased contracted sepsis, septic shock, after this abdominal surgery. And so the issue is sepsis, recognizing sepsis, the factors in the lab results that indicate sepsis, and how you treat sepsis. And Dr. Steggy testified that in every residence program in the United States, they teach the same way about recognizing sepsis and treating sepsis. And it totally was failed here. Samara Jackson died 4 days after she went into that hospital. I just want to point the court to the Tennessee Court of Appeals opinion of Ledford v. Moskowitz, 742 Southwest 2nd, 645. That court noted that...
Counsel, is that in your brief?
No, Your Honor.
Then that's fine, but just send a letter to the clerk.
Okay.
And just giving the name of the case, and you can argue it now, but just notifying the clerk of the name of the case and the style of the case, and copy your opponent. Don't argue it in your letter, just give us the site. Now you can argue the case.
All right, thank you, Your Honor. In that case, the court noted that the statute does not require, quote, precise knowledge of a community's specific medical standard. And in that case, with that particular expert, the court found the witness did testify that he had not been to Cleveland, Tennessee, which was the community where that case occurred, and did not know the number of hospitals, doctors, or physicians located there. Precise knowledge of specific medical statistics of a particular community, however, is not a requirement of the statute. So We respectfully submit that, or request that the court reverse the summary judgment, remand it, and with instructions to admit Dr. Steggy's testimony. Thank you.
Thank you. Of course, thanks to both counsel for their oral arguments and their briefs. I think we thoroughly understand your positions now. You've made those clear. If you would, please recess court until 1:30 this afternoon.